Hello, my name is Gina Clausen Lozier, and I'm an associate with the law firm of Berger Singerman in our Boca Raton office. I am on the dispute resolution team, and I specialize in complex commercial litigation with respect to insurance coverage. Well, insurance policies are all written in a very unique and complex language, which most people don't necessarily understand. And what everyone needs to understand, whether it be individuals who own homes, businesses, or with respect to condo associations and property management, is that all insurance policies have certain obligations. And if those obligations are not complied with, there can be mostly like a waiver of rights or almost prejudice to your rights of insurance coverage under the policy. And one of those obligations that's probably one of the most important is the obligation to provide notice of a claim. Well, all policies have an obligation to provide some type of notice, and notice can mean anything from prompt notice, immediate notice, or it can give an actual time period that notice has to be provided, whether it be within 14 days, 72 hours, etc. The policies typically don't define what prompt or immediate would mean, but the case law within Florida defines it generally as soon as a reasonable person would know that they may have a claim, they then have a duty to give notice to the insurance company. If you don't give notice to your insurance company, if you have a potential insurance claim, whether it be to a liability carrier for a defense or whether it be to a property carrier with respect to coverage for damages, you could prejudice your rights to recovery under the policy. And if you don't give prompt notice and it's found that the notice was not prompt, there's an automatic presumption of prejudice that attaches in favor of the insurance company. The burden then switches to the insured to attempt to overcome that prejudice to the insurance company for the insured's failure to give prompt or immediate notice of the claim. We recommend giving notice of a potential claim as soon as you would believe that you would have a right to coverage under your insurance policy. For example, if it was a property claim with respect to a hurricane and there was interior water damage, that would put a reasonable person on notice that they may have a right to coverage. If it was with respect to a liability claim, when you'd be asking the insurance company to defend you, if you receive a letter from a third-party claimant saying that they're going to be seeking damages against you or your company, at that point you should put your liability carrier on notice so they can do their coverage investigation and determine whether there's any duty to defend and or indemnify.